support to religion. So those two principles articulated in McCollum for the first time in 1948 have been described by a number of scholars, including by a law professor whom I work with at the University of Missouri, Carl Esbeck, as a novation. And lawyers in the crowd will know that a novation is to fundamentally alter a contract. But in a novation, you have all the contractors agree to that. Here, Esbeck argues that this decision was imposed upon, quote, unsuspecting states. This decision was unsuspected, surprising for state governments for a number of reasons. First, as to the application of the Establishment Clause in the First Amendment to actions of the state governments, that itself was seen as surprising, in part because the history of the First Amendment is such that it is hard to see that the intent of the First Amendment was to restrain state-level establishments of religion. Indeed, in 1791, when the First Amendment was ratified, 6 of the states had their own establishments of religion. So it seems difficult to imagine that the states, in ratifying the First Amendment, intended to take away what 6 of them at that time had, namely state-level establishments of religion. So it seemed that the First Amendment was intended to do what its language explicitly states, namely to restrain Congress. The First Amendment reads, of course, Congress shall make no law respecting an establishment of religion. So the application of the non-establishment principle was new, but also, in fact, in 1947, it had been addressed. But what is also new is the conjunction of the establishment of religion as a restraint on actions of the state governments with a new interpretation of what an establishment of religion actually means, or means in the eyes of the court. We can see that the idea that an establishment means any state-level support for religion, we can see that as odd from the perspective of the original intent of the First Amendment, because although at the time the First Amendment was ratified, 1791, 6 states had official establishments of religion in their states. By 1831, every single state had formally dissolved its state-level establishment, the last one being Connecticut in 1831. However, after officially disestablishing their state establishments of religion, many of those very same states continued to provide extensive support to religion, specifically in the form of state laws requiring prayers in public schools or Bible readings in public schools, which indicates, therefore, that an establishment of religion did not mean the same thing as any state support for religion. But the Supreme Court can be full of surprises. In this case was surprising. In McCollum, an Illinois city had an optional program of in-school release time, which took place in Illinois during lunch, where any faith community could bring, at its expense, a minister into the school to offer an optional Bible or Tanakh or religious study program. That program was entirely optional. No student had to participate. And in fact, the school had gone out of its way to make sure that alternative programs were available at the same time, programs in the gym or in art classes, so that no student would feel pressure to attend these optional events. But they were struck down. That program was struck down in 1948 in McCollum versus Board of Education, and the Supreme Court did so on the basis of its determination that an indwelling value inherent in the Constitution is that religion and the state best achieve, quote, their lofty goals when they are strictly separated one from the other. However, in 1948, over 2 million American school children around the world were participating, not around the world, excuse me, in the United States were participating in just such a program which had been initiated in 1910, nationwide set of endeavors to have these optional programs take place in public schools, and they had gone along without a hitch. So it's hard to see that it was a problematic program. Moreover, the Supreme Court rules in this case that the history of the First Amendment's non-establishment clause is encapsulated by the history of the state of Virginia. Virginia in 1786 establishes its Virginia Statute on Religious Freedom, which disestablished religion in Virginia. And in the eyes of the majority in McCollum, it was not a unanimous decision. In the eyes of the majority, they view my children here. Hello, son. Okay, well, you know, the kids are here for because they went to school, as you know. Okay, I think it's inside, honey. Oh, yeah. Okay. So what happens in McCollum is that the history of Virginia is seen to be controlling over the history of the whole country, i.e., the thought is that the founders intended for the First Amendment's non-establishment clause to apply to the states just as non-establishment had emerged in Virginia. But a friend of mine who teaches at American University, whom I have collaborated with, Daniel Dreisbach, argues that that's simply false, that was not the intent of the First Amendment to render such impositions on the states. So the Supreme Court can do surprising things. Now, enter a contemporary case. The case that I have listed there, Espinosa versus the Department of Revenue of Montana. This is a case that is currently pending before the Supreme Court. Decision in this case is likely by the end of the term, usually in late June. Let me give you the background to this case and why it's so fascinating. Montana established a law that allowed for a special tax deduction, a one-to-one tax deduction, for any charitable gifts given to specially state-designated charities, these charities being ones which offer scholarships to students to attend either private schools that are secular or private schools that are religiously run. A modest program, the tax deduction was capped at $150, but still the legislature and governor of Montana agreed to that. However, litigation ensued, and the Montana Circuit Court eventually makes a decision that on the basis of Montana's constitution, so a state-level constitutional determination, this law was unconstitutional against the state constitution, and it ordered that the Montana program be one where the tax deduction only accrues if the designated charity gives scholarships only to secular private schools. That was appealed to the Montana Supreme Court, and the Montana Supreme Court affirmed, in effect, that decision. Some technicalities about the case emerged concerning severability, but we can discuss that if you would like in question and answers. So the idea here is that the state of Montana is issuing a public benefit, but it is conditioning eligibility for that public benefit on not being religiously affiliated, because these special charities are not ones that the donors can get a tax exemption for donating to if the scholarships go to a religiously run school. Parents in Montana appealed this Montana State Supreme Court decision. They appealed to the only place they can go, from the highest court in the state to the United States Supreme Court. And it's that case, Espinosa versus Montana Department of Revenue, which the Supreme Court is wrestling with as we speak. The argument of the plaintiffs in this case is that a state program that extends a public benefit to secular-minded parents and schools systematically excludes religious institutions or religiously inclined parents from being able to participate in that program constitutes a violation of the free exercise of religion rights of parents and religiously run schools. Why? On what basis do they make that argument? They argue that the state constitution of Montana, which has been read to require the exclusion of religious schools from this charitable donation tax deduction program, that provision in the Montana Constitution is itself a violation of the U.S. Constitution, because the Montana program has the effect of requiring that citizens or organizations renounce their religion in order to avail themselves of a widely available public benefit. That infringes on the free exercise of religion, for if to get a publicly available benefit, you have to abandon your religion, you don't really have free exercise of religion. Such is the argument of the plaintiffs in Espinosa. The question is, how do we think the Supreme Court will rule on this case? As I said, it's pending, and we'll find out by the end of June. But I think it seems likely that the Supreme Court will rule in favor of the plaintiffs, in favor of the claimants, that is, the parents. And I think this on the basis of two earlier Supreme Court cases. I'm going to mention them just briefly. First, the 2002 case of Zellman versus Simmons Harris. In this case, the Supreme Court held that an Ohio program of school choice, which gave and continues to give vouchers to parents, for the parents to decide whether they want to take that voucher and use it to enroll their children in a private secular school or a private religious school, is not unconstitutional. Unlike the in class, that's an important thing here, the in school release time programs that the Supreme Court struck down in McCollum versus Board of Education. Unlike in McCollum, the court says in Zellman versus Simmons Harris. Unlike in McCollum, here the state is not involved because the grant is given to the parent, for the parent to exercise independent judgment about whether the parent wants the child to attend a private secular or a private religious school. Hence, the Supreme Court says there is no state aid to religion in violation of the Establishment Clause as it has been interpreted since the case of McCollum versus Board of Education. Second case that I think conjoins with that one to make a decision in favor of the claimants in Espinosa likely is a 2017, so quite recent case, rendered by the Supreme Court. And that case is Trinity Lutheran Church versus Comer. In that 2017 case, the Supreme Court ruled that it violates the free exercise of Trinity Lutheran Church and its associated school if, as there was the case in Missouri, a state law says that a publicly available benefit. Can you hear me here? That says that a publicly available benefit, in this case, recycled tires for use in playgrounds to avoid injury. The Missouri case, if we're able to right, thank you. That in that case, the Supreme Court ruled that it is unconstitutional to make available this public benefit of improved safety material in playgrounds. It's unconstitutional to make those unavailable to playgrounds on church-owned property. That in effect requires that church to forego its religious identity in order to be treated as an equal citizen, equal and on par with all other individuals and organizations in the state of Missouri. So that logic, the logic in Trinity Lutheran versus Comer, would seem to apply to the Montana case. Remember, in the Montana case, we have a situation where religious parents and religiously run schools, in order to freely exercise their religion and be able to participate in publicly available benefits, would have to thwart their religious identity, that they would have to, as it were, act as if they were not religious in order to be able to participate on an equal keel with all other organizations and entities in that state. So, on the basis of these two decisions, it seems that the court is likely to rule on behalf of the plaintiffs or the claimants, in the case of Espinosa versus the Montana Department of Revenue. However, as we saw in the 1948 case of McCollum versus Board of Education, the Supreme Court is full of surprises. Plus, McCollum is still good law, has not been overturned, and it casts, as I say on the outline sheet, its own shadows or penumbras. Penumbras, lawyers among us will remember, are the outlines, the faint outlines of shadows that Justice William O. Douglas referred to in his important case, Griswold versus Connecticut. Well, McCollum casts its shadows. Will the Supreme Court say in Espinosa, in the spirit of the McCollum decision, that when things involve schools and impressionable school children, that it will allow the state to have a policy of private school support that only goes to private secular schools, allowing secularity to reign in matters of public schooling. The Supreme Court is full of surprises, as McCollum itself shows, so we just don't know. And I happen to believe, and I'm arguing, that a policy that excludes religious parents and schools from a publicly accessible tax deduction program does in fact violate the free exercise rights of those parents and schools. But since the Supreme Court might not apply the logic found in Trinity Lutheran versus Comer, it might not apply that logic to this case. I'm looking in this article at other bases by which the Montana exclusionary rule could be seen as unconstitutional. And I'm happy to explore that with you if we have time. But what I'd like to do actually, first of all, is just to see if I could canvass the crowd here just a bit to see what your thoughts are about the Espinosa case. Again, tax benefit accrues to individuals who make a donation to a specially designated charity on condition that that charity make scholarship donations only to people who elect to use that scholarship at a private secular school, not a private religious school. Thoughts on that, anyone? Especially some of my former students or some of my new former students like Ms. Phillips and Mr. Washburn and all the others?
I think, and it might be too much to get into, excuse me, but I think some of it comes down to parental authority versus state authority in education too. You know, my thoughts lean more towards children not being mere creatures of the state and the Pierce versus Society of Sisters 1925 case.
Absolutely.
You know, so I think that would have to play into it too. I don't know if that's going to be on the Supreme Court's mind, but I think it would be.
I'm not 100% sure that that would be opposite, because there is no state level law which is prohibiting parents from, if they choose to pay for it, taking their children to a private religious school, as
True.
was the case in Oregon in Pierce versus Society of Sisters. And there actually was a ban on taking your kids to a private
Right.
religious school. But no, that's a very, very interesting and very, very helpful insight. So the idea, I think, Melanie, Heather, excuse me, is that since the control of the state allocated money resides with the parents, then that's enough to say, hands off state, let the parents use that as they see fit.
Yeah, because it's taking it away from the state religion conflict.
That is the core of the Supreme Court's decision in 2002 in Zellman versus Simmons Harris. So you're right on that. But other thoughts on this?
Hello, Dr. Prudhomme.
Yes, sir.
Yeah. So I definitely find that you have great and valid points, along with Ms. Phillips' points about, like, more or less allowing, we're trying to be creatures free from the state and being the liberal philosophy of John Locke and so on and so forth. However, I actually do see it as a possibility that the bar of revenue from the state of Montana could possibly win. So here I provide some devil advocate's point, because you mentioned so the Supreme Court builds its decision based on jurisprudence and based on stare decisis and previous decisions. And you mentioned one of your cases, like this is the one with Zellman versus Simmons Harris.
What?
Yes.
Yeah. Zellman versus Simmons Harris. So just giving the grants
just a little bit
to the churches that have like Sunday school and such, and more or less the Supreme Court say that you cannot deny them rights because they are like it's part of a religious institution and you cannot infringe on the right of religious institutes. However, I think there's a possibility that they would say that they could deny saying that you cannot spend the money on going to private religious schools, because on the previous decision the thing is, like, remember the case of Citizens United like 10 years ago, where it say like corporations are treated as citizens and thus they have the same rights as citizens. And more or less, there have been many, like, especially with the recent legislation with the CARES Act, they provide a lot of conditions to grants, like on loans to corporations, saying you cannot do this, you cannot buy it back, you cannot use this money to buy back stocks and such. And
Sean, can I interject here and to say that, as is your tradition in our interactions, over the years, it's a brilliant question and it's a brilliant insight. If I could just paraphrase it, if you will, and see if I'm capturing your thought here. Are you saying, be careful what you ask for? Okay, what do I mean? When Heather had said that we want to empower parents, well, Pierce versus Society of Sisters very much empowers parents. The state cannot tell you cannot take your child to a private religious school if you want to pay for it. But here, the state is giving the family member money. And that's a little bit different. Right now, you're in a little bit of a tango with the state. And so isn't it the case that the state may very well begin to condition, right, the receipt of that state money with certain kinds of strings and restrictions, right? Yeah. And so that's precisely getting at the rub of this case, because can the state condition the receipt of a benefit by saying you can only exercise that benefit in a secular way or at a secular establishment? Now, if we were to go down the road, as I actually think is the proper way for the court to go, and to say that the parents who receive that money should be able, if in their determination they choose, they should be able to take that money and enroll their students in a religious school. If we say that, then will there come freighted on top of that state grant restrictions on what that religious school can do? This is a pressing issue in our own state, my own state, of Maryland, because in Maryland, there is issues currently going on about whether this new Maryland program called Boost, it's a very small program, $10 million budget, but still, it is the initial foray under Governor Hogan of public funding in the form of vouchers to parents to use at religious schools, or in a secular school, as the parent should choose. There, the discussion is, well, can the state then say that the schools which receive students through the Boost funds have to have certain kinds of policies with respect to certain kinds of controversial social issues? And so some who are on the more libertarian wing of the kind of social conservative movement say, we don't want the state to have its nose underneath the tent of our own educational philosophy and establishments. When you take federal money or state money, in this case, be careful what you ask for, because the state may come telling you exactly how to read the Bible or exactly how to understand certain controversial issues, etc. Is that kind of your approach, Sean?
I also see that another reason why I think the government of Montana might win the case is because you mentioned about previously that there potentially might be a conflict within Montana's state constitution regarding the establishment of religion with the First Amendment. And I think because actually it's different than the Ohio case, because there was nothing, I don't think anything about it is like, because it was giving grants to religious schools, they didn't have anything to do with like the state government's trying to deny because of that state constitutional provisions. But I think the current composition clause, especially with now, you have more like federalist justices like Kavanaugh and
Kavanaugh, Gorsuch, etc.
Gorsuch, yeah. And
so again, Sean, go ahead, my friend.
Yeah, I think that, I mean, the Supreme Court, correct me if I'm wrong, but I know they do strike down state laws, but they're very careful about overriding state constitutional provisions, like in the legal codes. Maybe I don't know if the last thing they did was the Oakville v. Hodges with like the Southern states regarding same-sex marriage laws, but the thing is, I think a lot of the fellow justices like Gorsuch and Kavanaugh and the other conservative ones might be quite careful about like overriding
Okay,
state. Yeah,
Sean, again, my friend, excellent point. Absolutely excellent point. What this case would entail would be to overturn a provision in a sovereign state's constitution. Remember, we're a sovereign nation of many sovereign states. Okay, so that's fascinating. However, the Supreme Court throughout the entire post-World War II period, through its philosophy of incorporating the Bill of Rights as restraints against state governments, has long embraced the idea that it can override states when it thinks that states are in violation of its interpretation of the Bill of Rights. So, in other words, the ship is out of the harbor on that federalist argument. So now go back to one point here. Ohio and Montana and 35 other states have a state-level constitutional provision which goes under the title a state Blaine Amendment, named after James Blaine. A Blaine Amendment prohibits, as a matter of state constitutional law, the state from allocating state dollars to a sectarian institution or to an institution entirely under the control of a sectarian or religious institution. Now, Ohio has a Blaine Amendment, just like Montana. The Supreme Court of Ohio, however, ruled that because its voucher program gives the money to the parent, for the parent to decide, it is not the state giving the money directly to a religious school under the control of a religious entity. So a lot of this turns on how state constitutional or state Supreme Courts eventually interpret their own state constitutions. But in those states which have interpreted their state Blaine Amendment to mean that public money can go to a voucher to go to a private secular school, but cannot go to a voucher for use at a private religious school, in those states is where the federal government and the federal constitution may very well come in and simply say, despite the deference that we have to you, brother or sister state in the Union of Sovereign States, you're just wrong here. It just violates the First Amendment. It will be and Sean and other students here, Stacy, you remember this, it will be a juicy thing to see indeed, right? Okay, I know that we're a little bit kind of pressed for time. So Nina, I'll turn it over to you, my friend.
Well, thank you, Dr. Prudhomme. I think all of us thank you for your time. And I'm positive, because there's a few more discussions going on in the message box, I'm positive that Dr. Prudhomme would be happy to continue the conversation via email.
So if you don't mind, you see my email address there. Shoot me an email. Of course, if you're anywhere nearby and we can do it socially distancing, I'd love to get together with you for coffee. And also do keep in mind the Friday, June the 19th, Father's Day with the Founding Fathers, if you're interested for another Zoom session. So Nina, thank you so very much.
Of course, yeah. As he said, we have 2 more Zoom sessions coming up. His Father's Day on June 19th, and then also Dr. John Seidel will be offering an archaeological class on Thursday, May 21st, also at noon. So definitely join us for both of those. You can find information for both of those on the Alumni website, and we hope everyone has an excellent weekend. And we
stay well.
See you again soon.
Great, thank you all.
Thank you.
All right,
Thanks.
all the best.
No problem. Thank you.